which is going to come up by NTPC, we are in fact given them a benchmark at which the rate of the bidding rate should be below that, and that benchmark rate is lower than even the previous rates that at which the contracts have been awarded. Madam, so therefore we are introducing this concept. So we are introducing this concept so that the cost of project will really go down. And also Mr. Gupta had said that on hydro, why we are going in for micro hydro and why not go for China? In fact, you talked about 1,000 and 2,000 megawatts in China. In fact, the biggest power project in the world now, which is coming up in China, which is called Three Gorges, which is 18,000 megawatts, not 2 or 3,000 megawatts. But at the same time, in India, while we need such mega power projects, we also need small projects, because it is really necessary that even in district and small places, there is really no need that we generate power in one place and then transmit it from that place to another place. In fact, we must have also diffuse power distribution, and therefore to do that, we are also in the process of framing a new policy in which district will be considered as a unit, and whatever power resources are available in that district, whether it's a renewable resource or a fossil fuel resource or a hydro resource, that resource will be tapped within the district, and probably the power also will be distributed in that district. That would help in reducing T&D losses, but this also help in harnessing a resource in that district itself. So people will have a sense of propriety, and probably also because sense of belonging will be there, there will be a possibility for reduction of losses in a great deal. Madam, the social objectives is a very important issue which has been mentioned by everybody. And if you want to serve the social objective, the central government has never said that do not give subsidies. What we have said, you can subsidize any operation, but if you want to subsidize that operation, you must be able to pay for it. The state electricity boards cannot be asked to subsidize from their own resources, as a result of which, what Mr. Panda has said, such aberrations have been noticed. And therefore, if you want to remove those aberrations, we must ensure that subsidies, if at all has to be paid, must be paid upfront by the state government to the state regulatory committee, to the state electricity boards. If you cannot pay that, then subsidies otherwise cannot be borne by them, as a result of which the whole process really crumbles. Madam, I am sure we have taken care of all the apprehensions which the members have mentioned. Mr. Bogodia had mentioned about the central utilities. And
shall I now ring the bell?
Madam, just...
Because you're going to bring
Madam, I'll just quickly go through
Something unusual.
I have that power with me.
No, Madam.
I may use it, I may not.
No, individual members have raised some issues.
No, but
like,
you can reply them.
No,
and when you bring a comprehension, because we are 1.5 hours behind time. It's like the irregular electric supply. आप पूरा 2-4 मिनट में पूरा कर लीजिए.
Madam, you had said about availability based tariff.
Now you should not disturb him. Otherwise, I will have to ring the bell for you.
What you are trying to cover up is a total power policy as a whole. I think on suo motu you can bring up your power policy. You can have a discussion on this. This bill is very limited in the stricture.
Madam, 2 or 3 members have raised about availability based tariff and how the order of the CRC goes against the interest of the NTPC. Madam, if at all that order has gone against their interest, what is the best course available to them? The course is as mentioned in the Act itself. So they have gone to the court. We are not coming the way. So we are not hindered the functioning of the SCRC or the CRC in this case, or we are not allowed, we are not favored the NTPC, which is owned by the government 100%. So we are just told them that you can take a course which is available to you under the law. But let me tell you, when NTPC suffers, who benefits? The benefit of NTPC suffering goes to the state governments. It does not go to anybody else. So if that availability based tariff order is, you feel, is against the interest of the NTPC, it is the state governments who are feeling that that order should not have been stayed by the High Court. But of course that's the prerogative of the court. But the point is, so therefore the NTPC's gain is a loss of the state, or the loss of the states have to pay for it, the NTPC really gains. We have to have a proper trade-off between the two, and that trade-off can be attained only by the regulatory commission. But if the regulatory commission's order is not accepted to either of the parties, they can go to the court, but we should not stand as a jury in that case because we own the NTPC. Madam, Mr. Agarwal has really talked about many issues, including industry. Madam, the point is, in India, as I said...
I think you're taking too much time. I'm sorry, because the bill doesn't cover it. So you would say that you will bring a bill. I'm not allowing any more questions. No clarification. Please take your seat. The bill did not, in the beginning, I said, bill doesn't cover. There are so many bills before me. I can show you these. The ministers are waiting for a long time. That's why I said, bring a comprehensive policy before the House, and we should discuss it. We discuss it in a very...
He's thanking the members.
But thank them, and that's good. Now, no more more questions. Please sit down. No more. Same rule allows for you to. Please
Okay,
sit
in
down.
any case, madam,
He's talked already about the amendment.
whenever-
When they are forming the rules, when they frame the rules, at that time they'll take care of it. This assurance is
So,
given.
madam, whenever you give more time for discussion in the House, I will have the privilege of replying to some of the points that have been raised. And I'm sure Mr. Dipankar Mukherjee, when he raised some point the other day, there was about half an hour discussion anyway during the question hour. But I think the time that is required for this is longer than that. So I would be guided by your directive, and I will be
definitely.
answering those questions.
Today we have the Business Advisory Committee meeting. I would like to put it before myself. I would like to put it before, because I feel there is a lot more to discuss in the electricity bill, and we should help you in your good work, because just on this small bill, which was given half an hour, we have taken 2 hours, 3 hours. Yeah, 2 hours. 2.5 hours. So, never mind. But you have done a good job in replying to almost everything and the whole gamut of it. So we are satisfied, so don't feel bad about it. But please ask me that I should put the question. So I'll put the question is that the Electricity Regulatory Commission's Amendment Bill 2001 as passed by Lok Sabha be taken into consideration. Those in favor, please say aye.
Aye.
Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Motion is adopted. We shall now take up clause by clause consideration of the bill. Clause 2 stand part of the bill. Those in favor, please say aye.
Aye.
Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 2 is adopted. Clause 3 stand part of the bill. Mr. B.J. Panda did speak on it, but he did not move the amendment, right? Because you didn't ask me to move the amendment.
By the Honourable Minister, I withdraw both the amendments I have filed.
But you can move it and withdraw. If you don't want to move it, you have a freedom.
Yes, Madam.
Okay, fine. I shall now put clause 3 to vote. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 3 is adopted. Insertion of a new clause 3A by Shri B.J. Panda.
Same basis, Madam. I withdraw the.
You don't want to
in light
move
of
it?
Not.
Is that fine? With the rider that you will take care of these two amendments while you are framing the rules. Okay, thank you very much. I shall now put clause 4 as a part of the bill. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have. Clause 4 is adopted. Clause 1, the enacting formula and the title stand part of the bill. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 1, the enacting formula and the title are adopted. Shri Suresh Prabhu, to move that the bill be passed. Okay. The motion moved that the bill be passed. The question is that the bill be passed. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it. Bill is passed.
Thank you.
Thank you very much.
Thank you, madam.
Thank you very much. Even you replied my queries. Now we have. Now we have a repealing and amending bill jointly, Bill 1999. Now Mr. Arun Jaitley explained to me, and which he will explain to the House. As we took so much time on a bill which was really necessary, however small it might be, but this bill is regarding like yesterday's bills, which had become redundant, or they were replaced by some other enactment, or they had some mistakes in the while drafting, and so they have no power, they have no authority to be just wasting the space in their ministries or wherever they are. So that's why he has come with 300. How many there are?
357.
357 bills at a stroke we will withdraw.
One about 356.
Without discussion. Who is this? रामनाथ कोले जी आप भी मत बोलिए इस पे कौन बोलेगा मंत्री जी बोलेंगे बस and then we'll pass it like we did a good job yesterday.
Madam,
Ji.
I propose to the Honorable House that the Repealing and Amending Bill 1999 be approved by this House. It seeks to repeal wholly or partly 357 different legislations. Some of them are sought to be amended. These are broadly in three categories. I'll just explain each of the three categories. The first category to which most of them pertain, these are all amending legislations. There is already a principal legislation. Subsequently, an amending law is passed. By virtue of that Amendment Act, the amendment gets incorporated in the principal legislation and it becomes a part of the principal legislation. But that law by virtue of which the amendment was passed continues to occupy the statute book. And under Section 6, capital A of the General Clauses Act, the amending bill actually becomes redundant and the repeal of the amending bill does not in any way affect the operation of the principal legislation into which it has been incorporated. And therefore, this is a regular exercise which the Department of Legislation does. It's called cleansing the statute book or scavenging the statute book, that all those enactments which are occupying the statute book but serve no purpose are sought to be repealed. So the first category, most of these belong to the category of those amending bills. The second category are those which were legislations which lapsed by virtue of time. The legislation was for a limited period. It lapsed when the period was over. But in order to remove it from the statute book, a specific repeal legislation is required. The second are a few laws in that category. The third is an exercise which we do, which happens but rarely in cases of some legislations, where while the legislation after being approved by this House, certain printing errors or other errors are seen and are noticed regularly when we review those legislations. Those are sought to be corrected by virtue of an amendment. So the first schedule to this Act comprises of legislations which are 355 in the first and the second category. That is the amending laws or the laws which have already lapsed. The second is those cases where certain errors had crept in when the primary legislation was drafted. In this case, it happened in two cases, the Indian Succession Act in relation to the succession of those Parsi gentlemen who expire without a will intestate and without any lineal descendant as to what would be the order of inheritance. And the words grandparents' children should actually have been grandparents' parents' children. And this was an error which was noticed in the schedule, so that is sought to be corrected. The second amendment is to the Code of Criminal Procedure, to Section 377, which deals with unnatural offences. In the original legislation, it said ditto because it copied what the previous legislation, that is 376 and 376B, mentioned. Once there was an amendment and 376D, C and D got added, the ditto was not changed and it became dittoing what was the new piece of legislation. So technical error came into Section 377, which was noticed in the course of the enactment being implemented, and that error is sought to be corrected by this amendment bill. The Standing Committee has examined each of these 357 legislations in detail and has been unanimously returned a report that these require to be repealed or amended. And I propose to the Honourable House that this bill be adopted.
I think the House understands and they have been understanding, so I'll do that.
Discussion is redundant.
So, discussion is redundant actually. And discuss on what? No, I understood it because... Never mind. There are many lawyers here. I have become half lawyer now, sitting here.
Bills. There are 10,000 bills which have to be repealed.
We shall now take up. So,
And Arun Jaitley should invite for lunch and we pass the bill.
that any...
You'll have to invite 50 law ministers of the previous leader. Because 400...
You don't worry, sitting in the chair, I can give a direction to any one of you also to invite the whole House.
I think we have had enough discussion on this subject.
The question is that the repealing and amending bill 1999 be taken into consideration. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it, motion is adopted. We shall now take up clause by clause consideration of the bill, clause 2 to 4. The first schedule and the second schedule stand part of the bill. Those in favor please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have a clause 2 to 4, the first schedule and the second schedule are adopted. Clause 1 stands part of the bill. There is an amendment by you, Mr. Jaitley. It's about the date.
It's about the date, Madam. I propose Madam, I propose that the amendment be approved, but taken into consideration.
Amendment moved. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it, the amendment is adopted. I shall now put clause 1 as amended to vote. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have a clause 1 as amended is adopted. The enacting formula stands part of the bill. There is one amendment, Shri Arun Jaitley. It's
Madam,
also
I
regarding
propose
the
the
dates.
amendment be taken into consideration.
Amendment moved. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The amendment is adopted. I shall now put the enacting formula as amended to vote. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The enacting formula as amended is adopted. The title stand part of the bill. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Title is adopted. Shri Arun Jaitley to move.
Madam, I move that the bill be passed.
As amended.
Madam, I move that the bill as amended be passed.
I hope you don't bring it again because you brought an amendment to it. So we have to repeal it also next time. I hope it doesn't happen because we can do it today only. Motion moved that the bill as amended be passed. The question is that the bill as amended be passed. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The bill as amended is passed. Thank you very much. So, now we have...
Request to make to the House that the next bill is about marriage laws. It may take little more time because many women members would like to speak. So I was just... I'll tell you why. I will tell you why. Because this is in favor of women.
So they may oppose
The
it.
bill is in favor of women.
Mr. Minister, the men might oppose it.
That's why I said, ma'am.
So, ma'am, I was proposing that there are next two bills the ministers are sitting. One is very simple repeal bill and another is small bill. If we can take this, because like marriage laws amendment, we have today introduced amendment to CRPC 125, which is identical to this. So we can think in BSc whether we can have a discussion together and all that. So my request was if we can jump to 6 and 5 before 5, then marriage laws can be taken into consideration.
Which one? Both of them. One is Warehousing Corporation Amendment Bill 2001.
First take 6 and then 5, ma'am.
Okay.
6 is just a repeal bill.
The sugarcane cess validation repeal bill. Who is taking it? Prasad. Mr. Prasad.
there, Minister?
Yes,
They are
Mr.
sitting
Prasad.
there first.
You can move it. Move the motion. आप थोड़ा आगे आ जाइए. You will have to come in front. You come in front and just say that. You just say to move a motion for consideration of the sugarcane cess validation repeal bill 2000. बस इतना ही बोल दीजिए.
Madam, I beg to move that the bill to repeal the Sugarcane Cess Validation Act 1961 be taken into consideration.
And you want to, that's it, there is no discussion on it, no, so, that's it, okay. Motion moved. The question is that the Sugarcane Cess Validation Repeal Bill 2001 be taken into consideration. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The motion is adopted. We shall now take up clause by clause consideration of the bill. Clause 2 stand part of the bill. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 2 is adopted. Clause 1, the enacting formula and the title stand part of the bill. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 1, the enacting formula and the title are adopted. Yes, Mr. Prasad, that the bill be
I
passed.
also move that the bill be passed.
Thank you. The motion moved that the bill be passed. The question is that the bill be passed. Those in favor, please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Bill is passed. Thank you. Now I have to go for the business advisory. Somebody should take the chair. Where is Mr. Kaushik ji? One bill. Acha, I will finish this one bill and then you can. Okay, fine. The Warehouse Corporation Amendment Bill 2001 जी मूव करिए श्री राम चौहान जी.
उपाध्यक्ष महोदया, मैं यह प्रस्ताव करता हूं कि भंडागारण निगम अधिनियम 1962 का और संशोधन करने वाले विधेयक पर विचार किया जाए.
ओके, मोशन मूव. The question is that the Warehousing Corporation Amendment Bill 2001 be taken into consideration. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it, the ayes have it. Motion is adopted. We shall now take up clause by clause consideration of the bill. Clause 2 to 6 stand part of the bill. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 2 to 6 are adopted. Clause 1, the enacting formula and the title stand part of the bill. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 1, the enacting formula and the title are adopted. Shri Chauhan ji.
मैं प्रस्ताव करता हूं कि विधेयक को पारित किया जाए.
Okay. Motion moved that the bill be passed. The question is that the bill be passed. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Bill is passed. Thank you. Kaushik ji. It go back. Arun ji, you want to bring the marriage laws now?
Ready for marriage.
Not while I'm not in the chair. The women will not be protected. हम महिलाओं की सुरक्षा करेंगे.
Sir, I propose to this Honourable House that the Marriage Laws Amendment Bill 2001, which has been taken up for consideration, be approved by this Honourable House. So the government had undertaken a study. We had discussions with several organizations, women's organizations, other NGOs, legal bodies, Law Commission, on the subject of maintenance as far as women are concerned in matrimonial issues, whether there are disputes or otherwise. And two different legislations have been proposed to this Honourable House. The first relates to the Marriage Laws Amendment Bill 2001, which has been taken up for consideration, and the second is Section 125 of the Code of Criminal Procedure, which has been introduced into this Honourable House today morning itself. So by virtue of this amendment bill, there are four different legislations which are sought to be amended. They are namely the Indian Divorce Act, the Parsi Marriage and Divorce Act, the Special Marriage Act, and the Hindu Marriage Act. These laws, in the subject matter of award of maintenance to wives, have been almost brought to uniformity, and the following changes have been proposed as far as these laws are concerned. The first is that whereas in the existing legislations, wherever there was a provision for payment of alimony to a wife in a matrimonial dispute by a court, it has been extended to also include the expenses of the proceedings. Some of the laws provided for both maintenance as also expenses of proceedings, some did not, and they have been brought. The second change which has been made is that educational and maintenance expenses of the children have also been included as far as the maintenance is concerned, The laws have been brought at par as far as they are concerned. And the third change, which will have a very far-reaching effect, is that an effort has been made to indicate a time period within which the award of maintenance ought to be decided by the courts. Now, this is within the area of all civil proceedings relating to matrimonial disputes which are initiated. The proceeding with regard to timing now indicates that in a proceeding where an application for alimony or expenses is made, it shall be the endeavor of the court to dispose it off within a period of 60 days, that is within a period of approximately 2 months. Currently, what has been seen is that across the country, there are lakhs of matrimonial proceedings which are pending, and in those matrimonial proceedings, because wives normally are financially unable to maintain themselves, children are obviously unable to maintain themselves, and when applications are made for the award of maintenance, alimony or expenses of proceedings, the decision with regard to this itself takes a very long period of time, in certain cases several years before it is disposed of. And the wife being at a receiving end, not being in a position to maintain herself, is normally put to a situation of virtual starvation when these orders are not passed by the courts, and therefore a time limit is being sought to be indicated that as far as possible this ought to be done within a period of 60 days. I may also mention this House will in the next few days, when it is taken up for consideration, have an opportunity to also discuss the accompanying bill, which is the amendment to the Section 125 of the CRPC. That's a separate amendment which has been introduced, which has been the purpose of which is that there was an upper limit, a cap which was fixed by the statute way back some 41 years ago, whereas the cap itself indicated that the maximum amount which could be awarded was rupees 500. The Law Commission had made a recommendation for increasing the amount, but the government took a view that since the awards are going to be made in relation to the capacity of the husband to pay, therefore it would be left to a judicial discretion, and this upper cap of rupees 500 has been removed. Simultaneously, in that legislation also, a provision has been made for the award of interim maintenance, where there was no statutory provision to that effect, and the 60-day identical time limit has been indicated even in that provision. So all these legislations are being sought to be brought at par, and also an element of expedition in the award of these maintenance. That is the purpose of these amendments, and I propose to the Honourable House that these amendments be accepted and this bill be approved by the Honourable House.
विवाह कानून संशोधन विधेयक 2001 प्रस्ताव के रूप में प्रस्तुत हुआ। अब माननीय बीपी आप्टे
The Honourable Law Minister, first of all, I congratulate the Honourable Law Minister for bringing forth these amendments. But I have one suggestion to make on the maintenance aspect, where you have removed the upper cap of 500 rupees. I would suggest, when you are considering moving that bill, that whatever the court decides to be the level of maintenance, supposing the court says it's 5,000 rupees, then it's impossible during the course of the litigation to change that figure. As you as a lawyer know, that once the maintenance is decided, it normally remains at that figure. Even if it remains at that figure, please indicate in that legislation and move an amendment by which whatever the court decides, the maintenance shall be increased and linked to the increase in the cost of living index. So that what is 5,000 rupees today, if the litigation takes 10 years, if you relate it to the cost of living index, then the person concerned will get a higher level of maintenance, even if there is a 5,000 rupee order by the court. Whatever the court decides, it may be 5,000, maybe 2,000, maybe 10,000. Since you raised that issue, I have taken the liberty of seeking the permission of the chair and suggesting it to the Honourable Minister.
माननीय बीपी आप्टे।
I rise to support the bill, which really is a part of the process of judicial reforms. जो कानून में संशोधन यहाँ प्रस्तावित हुआ है, उसमें मुख्यतः लिटिगेशन के चलते जो इंटरिम मेंटेनेंस की आवश्यकता रहती है और उसके लिए एप्लीकेशंस होते हैं, उनके बारे में है, और सभी न्यायालयों का अनुभव ये है कि ये एप्लीकेशंस जो जल्दी ख़त्म होने चाहिए, जिन पर जल्दी ऑर्डर्स होने चाहिए, ये वर्षों तक पेंडिंग रहते हैं, एंड द मेन लिटिगेशन कंटिन्यूज टू बी पेंडिंग, and even the application for interim relief continues to be pending for years. So we have already enacted the Family Courts Act, under which family courts are established in many cities, where the act itself provides for an outer limit for the completion of the litigation. But in those family courts which are expressly established to give speedy relief to the matrimonial litigant, cases are continuing to be pending for years together, and even an application for interim maintenance and for expenses is kept pending for 2 to 3 years in a city like Mumbai. Therefore, this amendment, which seeks to put as far as possible an outer limit of 60 days, is a welcome amendment. But looking to the way the judicial process winds itself on the road, I must say frankly, I am doubtful about the efficacy of this amendment. This amendment may put a moral pressure on a judge that there is a provision in law that I must decide this application within 60 days. But the pitfall here is the phraseology as far as possible. And the judicial process, as I have seen it for about 40 years, I find that this as far as possible is a way out for continuing the delays. Therefore, since this is a part of the process of judicial reform, I think it is time for us to consider the provision for some kind of an accountability in the functioning of the judiciary. A judge takes 4 years to decide an application for interim relief, and for that negligence, if I may use that word, he is not accountable. I believe in the judicial process in this country, a time has come where a judge is made accountable for the proceedings before him, and therefore if in such a situation, because all of you know that there is industrial legislation where a time limit is put on everything, but that time limit is as a rule ignored. If it is not to happen in respect of this time limit also, at least some provision that if he exceeds that period of 60 days, and if he does not decide an application for interim relief, he should do that by giving reasons for that delay. And under the Code of Civil Procedure, under the directives of the Supreme Court, from time to time, if he is not granting adjournments easily, a judge will be in a position to decide matters within 60 days if he means to do that. And if he doesn't mean to do that, he will have to furnish reasons which he will not have, and he may find some difficulty in delaying the matters. Sir, I am aware that here I am putting the blame entirely on the judge, even though in many cases the litigants themselves contribute to the delays. And it doesn't depend upon whether the litigant is a plaintiff or a defendant. The litigant, for various reasons, including some kind of muhurt, delays his own litigation, and therefore the litigant is also to blame. But if we want to ensure that a woman who is driven out of her house, a woman who must be maintained and which is the responsibility of the husband under the present laws, must get the relief when she needs it. She getting a relief when it is already too late will be meaningless, and therefore if she has to get relief, and in some laws this proposal for payment of the expenses of the proceedings were not there. In some laws they were already there. In the Hindu Act it was there, in other acts it was not there, it is now provided. Then those expenses which she has to make during the litigation on every date for which she comes, those expenses must be paid to her immediately, and therefore it is laudable that this provision is sought to be made in all these enactments for the purposes of an outer limit of 60 days. And as I said, this as far as possible will have to be dealt with in a salutary manner by making the judge accountable one way or other by legislation here or an independent legislation for the accountability of judges. Sir, when I found that we have several enactments to deal with a single civil situation where a woman is neglected, where a woman is entitled to maintenance, I also thought that it is time now that instead of having all these separate enactments to deal with separate sections of the people in the same civil situation, why not they be governed by a common civil code? It is time for the country to come to a conclusion that as a civil society, as one society, it is for us to consider to be governed by one single law which governs the relationships of persons in their personal life and which governs the relationships of persons in their public life. If we have common property laws, why don't we have a common personal law dehorse the religious considerations? If people consider that a marriage is not a contract but a sanskar, let them have their own sanskar. But insofar as the relationship and the legal rights that flow from them, let there be a common approach, let there be a common civil code. Before that, some common arrangement is sought to be made by this legislation, which is really laudable, for which I congratulate the minister, and I would seek that each one of us supports this bill, which seeks to ameliorate the situation to a certain extent.
Thank you. मान्य मैबल रिवेलो नहीं, मान्य प्रोफेसर भारती रे।
And it deals with the most crucial aspect of the lives of men and women, especially women. And the women's movement in India has a long tradition of demand for legal reforms. One could speak for 1 hour on Hindu Marriage Act or in Divorce Act, but I am not going to do that. No, I will not do that. I will confine myself only to the points.
क्या पॉइंट ऑफ ऑर्डर क्या? हाँ बोलेंगे आप,
उसका नंबर काट के पीछे बोलेंगे क्या?
बोलेंगे आप। आपके पार्टी के मेंबर तो सबसे ही पहले बोल लिए।
नहीं कौन
कपिल सिब्बल साहब।
सिब्बल साहब ने तो हमसे रिक्वेस्ट किया, नहीं मेंबर जब नाम देते हैं या
अरे आते हैं आपको मिलेगा।
ऐसे थोड़ी चलता है, बैठे रहोगे इस तरीके से थोड़ी चलता है। आप शक्ल देख के किसी को बुला,
जब वो नहीं है रेबेलो तो तुम
आप शक्ल देख के किसी को बुला, ये तरीका थोड़ी।
नहीं ये ऐसा कुछ नहीं।
जब हमारी
आप बैठिए, आपका नंबर आएगा।
बोल नहीं रहा मैं तो ये कह रहा हूँ,
अब आप आसन
नियम से जब हमारे मेंबर नहीं है तो दूसरा मेंबर का नाम भी हो सकता है हमारे।
हाँ तो है दूसरा नाम,
ये तरीका थोड़ी है दूसरे पार्टी के लोगों को बुलवाते जाओ और उनको छोड़ो।
बैठिए, महिलाओं का जरा मौका पहले दीजिए।
मैं उसका जो अपोजिशन का महिला बोल रही है उसका नहीं कर रहा,
केवल इसीलिए
उस नियम से
केवल इसीलिए कि महिला का विधेयक महिलाओं के लिए विशेष रूप से है, इसलिए महिला को पहले मौका दिया जा रहा है। रिबेलो का पहला नंबर था लेकिन वो नहीं है। बोलिए।
Shall I? I have no problem if you want to speak first. Okay, my this concentration is gone. Yes. Anyway, I'll try to recover. Okay, I'll recover. So, what I wanted to say that women's movement, one could. It is a very important, crucial. And we can speak for a long time, but I don't want to do that. It's all the late hours. I'll confine myself only to the 4 things. But before that, I want to make 2 very small points. That is one thing. women do not seek divorce, and they go to the court only when compelled. There is so much social pressure and so much social shame and stigma attached to this that women, for women divorce, and I wanted actually to give you instances, but I won't do it now, no time. And but this one has to bear in mind. For women, if they want to, most men actually records show that more men want divorce, file cases for divorce. But if women, what is the point over?
अरे आप agree मत कीजिए, आप अपनी बात
which one?
जब आपका नंबर आएगा आप बोलिए.
No, I want to hear. Peter, what did you say? Peter, what did you say? What is it? अरे बोलो ना. ना क्या बोला? Surface proof. This is, I am saying from surface, it's not opinion. Anyway, this you will agree that if women, most women who ask for, this we agree, most women who ask for divorce, ask it for on the grounds of cruelty and adultery, both of which are very difficult to prove because they are private matters. So women, in divorce cases, women should be really given some extra consideration and thought. In this context, I look at the bill. And I will, it is a progressive step. Mr. Minister, it is a progressive step. And it will help many a woman who suffer from a failed marriage. Those of us who work with women in distress and who suffer from the trauma of this divorce, sense of powerlessness, and sense of financial helplessness, they will be helped by this bill because it has got two major points. One, that the alimony is given, money is given for the expense of the proceedings, and then very, very important step, the 60 days limit. So in these two aspects, I will say that is a progressive step, and thank you, Mr. Law Minister, for this. But having thanked you, I would like to say that these would be effective really under certain circumstances. I'll turn to the Indian Divorce Act first. Sir, there is this C, clause C, I think, no? And this extracts, it is 36, or clause 36, paragraph 3. The upper limit in no case will exceed 1/5 of the husband's average salary. That is the bill. Upper limit has been fixed 1/5 of the husband's salary. Yes, it is 1/5. That is upper limit. I think that this is a retrogressive step and therefore should be avoided. That is, in your bill, I would suggest, sir, that a more liberal and humanitarian approach would be to base the maintenance amount on the wife's and the husband's status as an equal partners in marriage. Of course, original act, it's there. Yes, this original act is here. Yes.
Sir, in the winter session of Parliament, I had an occasion to introduce before this Honourable House a comprehensive amendment to the Indian Divorce Act.
I see.
Because amendments to the Indian Divorce Act were pending for a long period of time. There were certain provisions which had been struck down by courts as being discriminatory against women, and there were certain other provisions which required a detailed review. After it was introduced, even before it was introduced, we had comprehensive discussions with members of the community, women's organization, various other church authorities, and subsequently it was referred to the standing committee. The standing committee has also considered the matter at length, and in this very session, hopefully after the report of the standing committee, all those comprehensive changes will be coming up for discussion.
Oh,
so those matters you can
refer
to.
That's okay. That's very nice. Then that is that. The second point, that I come to the Hindu Marriage Act. That's extra in 1955. The most important point, Mr. Law Minister, you have to listen to this, please. The most important point that I want to make here is, what will the woman do for 60 days? Where will she stay? This is what I want to know. So, I request you humbly and very fervently and with all the power that I have in my command, sir, please introduce women's right of residence in matrimonial home. If you send the girl to her parents' place, in Bengali, I'll say, "Tomake shami nahi na? What has happened to you?" People, neighbors come, doesn't your husband take you? Or ask the parents, your husband, daughters, your jamai, doesn't take the daughter. It's a very, unfortunately, it's a stigma. And they can't stay at the parents. They can't go to stay away homes. So, you please add. You know, Begum Rokeya Sakhat Hossain, actually the first feminist in South Asia, whom I call, she wrote a brilliant article in 1905 or 1906, is entitled Griho, home, where she said, "Meyeder ghor nei, we have no homes. Either we have baper bari, father's home, or shoshur bari, that is the in-laws home. At most we have mama bari, uncle's home, but women have no bari, no griho." That was Begum Rokeya in 1906. So what I want to say, that right of residence in matrimonial home, sir, 1 minute, I have a very good friend who after 20 years of marriage came back home and was told that she could not enter the home. And she has not been able to enter it so in this at least 2 years. So right of residence in matrimonial home is a must, and Mr. Law Minister, sir, you are so liberal, so please do something about it. Right of co-tenancy. I mean, I am not lawyer, I don't know how to frame it. But what I want is that the woman can stay without fear of physical torture in the house where she entered after marriage. The second point I want to make is this, that you have this provision of monthly, 1, 2, 3, 4, line 5, clause 24, line 5. This monthly payment. I think the Bangalore Law School 1988, they recommended that a provisional amount arrived at by a division of equal share for the wife and children covering 3 months should be deposited at the court. And now you can say 2 months. But you see, monthly payment is a hassle. And this is a suggestion from the Bangalore Law School. And the third point I want to say during the discussion is this, that what about any discussion on the amount of maintenance becomes academic, because in the majority of cases husbands evade payment. So is it possible, if he refuses to honor the court verdict, we will take him to the court again. Is it possible to attach his salary or to issue a warrant of attachment under the CCP? This is this clause. No, that clause is no. No, remanded means to the court. But I am saying the attachment of salary or attachment of no, that is not there. It is possible. It is possible. So that is what I want. Yes. These are the 3 suggestions I make. Of these 3 suggestions, the matrimonial right to matrimonial residence is the most important one. Thank you.
माननीय मूलचंद मीना.
सभापति महोदय, अपनी महिला नहीं थी इसलिए बोल रहा हूं. The Marriage Laws Amendment Bill 2001 मंत्री महोदय ने पेश किया. बिल के अंदर देखने पर पाया कि एक अच्छी भावना के साथ एक अच्छे उद्देश्य के लिए ये बिल लाया गया. इस बिल से भारतीय विवाह विच्छेद अधिनियम 1869, पारसी विवाह और विवाह विच्छेद अधिनियम 1936, विशेष विवाह अधिनियम 1954 तथा हिंदू विवाह अधिनियम 1955 का संशोधन के लिए लाया गया. इस बिल के पास होने के बाद भारतीय विवाह अधिनियम 1869 की धारा 36, धारा 41 का संशोधन है. पारसी विवाह विच्छेद अधिनियम 1963 की धारा 39, धारा 49 में संशोधन, विशेष विवाह अधिनियम 1954 की धारा 36, धारा 38 का संशोधन, हिंदू विवाह अधिनियम 1955 की धारा 24, धारा 26 का संशोधन है। सभापति महोदय, इस देश के अंदर वैसे तो विवाह विच्छेद से संबंधित, पति पत्नियों के संबंध विच्छेद के संबंध में अनेक केस, हजारों केस हैं जो पेंडिंग। हिंदू विवाह अधिनियम 1955 के अंदर धारा 24 के अधीन 670 केस ऐसे मामले हैं जो कोर्टों में चल रहे हैं। तो मामलों में देरी, ऐसे निर्णयों में देरी होने के कारण भारतीय विधि आयोग की एक रिपोर्ट 27वीं, 54वीं, 129 रिपोर्ट जो आई, उसके आधार पर, उसकी सिफारिशों पर, अधीनस्थ विधायी संबंधी समितियों की सिफारिशों के आधार पर इस कानूनों के अंदर जो संशोधन किए जा रहे हैं, एक अच्छे कॉज के लिए, अच्छे काम के लिए, कि कोर्टों में केस चलते हैं तो लंबा टाइम, बहुत टाइम हो जाता है, उनको एक सीमा में रखने के लिए, एक सीमा में बांधने के लिए, समय निश्चित करने के लिए। साथ ही कई ऐसे मामले होते हैं, बाद विवाद चलता रहता है, पत्नियों की दयनीय स्थिति होती है, उनके भरण पोषण के लिए, बाद में चलाने के लिए उनके पास पैसा नहीं होता है। ऐसी स्थिति में कई केसेस तो चल ही नहीं पाते हैं, लड़ी नहीं पाती हैं महिलाएं, उनको उनके सामने बहुत दयनीय स्थिति होती है। उस स्थिति को दूर करने के लिए ये व्यवस्था इसके अंदर की है। लेकिन जो संशोधन आप लाए हैं, इस संशोधन में कोई भी पत्नी पीड़ित है, उसके पास आर्थिक स्थिति कमजोर है, तो उसके पति से हिस्सा प्राप्त करने के लिए, मंथली हिस्सा प्राप्त करने के लिए 3 वर्ष की औसत शुद्ध आय का इसके अंदर विवरण दिया गया है। लेकिन देखने को यह मिलता है, गांव के अंदर भी, शहर के अंदर भी, जिन पति और पत्नियों के संबंध विच्छेद होते हैं, पहले तो उनके नाम प्रॉपर्टी होती नहीं, उनकी कोई आय होती नहीं, और किसी की आय, बहुत सारे मामले ऐसे हैं जिनके अंदर पति नौजवान होते हैं, नौजवान संबंध विच्छेद हो जाते हैं, कोर्ट में चले जाते हैं, तो उनके नाम से न कोई मकान होता है, न जायदाद होती है, न कोई व्यापार होता है। ऐसी स्थिति में उसके 3 साल का 5वां हिस्सा तो कैसे उसको तय कर पाएंगे कि उसके भरण पोषण का पूरा हो सकता है। ऐसी स्थिति में फिक्स कर देना चाहिए कि 5,000 रुपये मंथली, 4,000 रुपये मंथली या 3,000 रुपये मंथली, एक फिक्स उसको रकम दे दी जाए मंथली, तो उसका भरण पोषण हो सकता है। इस आधार से तो कई लकूने रह गए, इससे कई लोग फायदा उठा जाएंगे और उन महिलाओं के साथ अच्छा सलूक नहीं होगा, बेचारियों के साथ उनका भरण पोषण नहीं हो पाए। दूसरा, इसके अंदर पृथक्करण के जो बात चल रहे हैं, तो इसका सबसे ज्यादा असर संतान के ऊपर होता है, आवश्यक संतान के ऊपर असर होता है। उनका कोई भरण पोषण का कोई व्यवस्था नहीं, शिक्षा की कोई व्यवस्था नहीं। ऐसी स्थिति में ऐसी संतानें गलत हाथों में चली जाती हैं, कोई आतंकवादियों के हाथ में चली जाती हैं, कोई गलत धंधे करने, मादक द्रव्य बेचने वालों के हाथ में चले जाते हैं, उनका कोई रास्ता नहीं होता उनके सामने। इसलिए उसकी रक्षा के लिए ये व्यवस्था तो आपने की है, लेकिन इसका भी कोई फिक्स एजुकेशन का, भरण पोषण का फिक्स जो आधार बनाते हुए फिक्स रकम, फिक्स पैसा रख दिया जाए तो एक अच्छा होगा, जिससे कि उनका भरण पोषण भी हो सकता है, उनका शिक्षा भी हो सकती है। और नहीं तो इस बिल के लाने का जो उद्देश्य है, जो लाभ पहुंचाने का उद्देश्य है महिला और बच्चों के लिए, वो उद्देश्य पूरा नहीं हो पाया, क्योंकि कई पतियों की आर्थिक स्थिति का पता ही नहीं लगा सकते। न तो उनके नाम से कोई जमीन जायदाद होती है, न उनका कोई धंधा होता है, न व्यापार में हिस्सा होता है, तो उनकी औसत आय कैसे निकाली जा सकती है। इसलिए मंत्री महोदय, आप दोनों के लिए उनकी रक्षा के लिए फिक्स अमाउंट्स इसके अंदर कर दिया जाए तो ये ठीक रहेगा। दूसरा, आपने इस बिल में संशोधन के लिए एक ये बात, नई बात जोड़ी आपने कि जो एप्लीकेशन भरण पोषण के लिए जब केस चल रहा हो, विवाद चल रहा हो, भरण पोषण के लिए उसमें फिक्स अवधि 60 दिन की किया कि एप्लीकेशन लगाएगा उसके भरण पोषण और शिक्षा की व्यवस्था के लिए और लेडीज के लिए अपनी निर्वहन के लिए 60 दिन के अंदर उस एप्लीकेशन पर फैसला करके उसको वजीफा दे दिया जाएगा। लेकिन ये 60 दिन ज्यादा हैं, अधिक हैं, इसको कम कर दिया जाए, 60 की बजाय आप 45 कर दें, 30 कर दें, तो उनको जल्दी लाभ होगा। दिन पर दिन ऐसी स्थिति बनती जाएगी कि 60 दिन में 60 दिन का आप इसमें क्लोज रख रहे हैं, लेकिन स्थिति ऐसी हो जाएगी 60 दिन के अंदर कहीं के कहीं डुल जाएंगे वो लोग। इसलिए इसको जितना जल्दी उनको वजीफा मिले और जितना जल्दी उनको भरण पोषण की शिक्षा की व्यवस्था के लिए अमाउंट्स मिले, प्रति माह मिले, तो वो अच्छी सुविधा उनको हो सकेगी। क्योंकि ऐसी स्थिति गाँव के अंदर बहुत बड़ी दयनीय स्थिति है बेचारी ऐसी महिलाओं के साथ। गाँव में संबंध विच्छेद होते हैं, केस चल रहे हैं, उन पतियों के नाम न कोई जमीन है न कोई धंधा है, तो उनके सामने तो भयंकर संकट। इसलिए समस्या को दूर करने के लिए आप बिल लाए हैं, अच्छी भावना है आपकी, महिलाओं के प्रति सोच भी अच्छा है, तो आप फिक्स अमाउंट्स कर दीजिए जिससे इनके दुख दर्द अपना निवारण कर सकें, अपने बच्चों का पालन पोषण कर सकें, बच्चों का जीवन का शिक्षा की व्यवस्था कर सकें, जीवन निर्वहन कर सकें। ऐसी व्यवस्था आप करें तो इस बिल का मकसद सही होगा, यही मैं कहना चाहता हूं।
माननीय प्रभाकर रेड्डी।
Thank you, sir. Sir, I rise to support the Marriage Law Amendment Bill 2001 introduced by Honorable Law Minister. Sir, the objects underlying the amendment are undoubtedly laudable, and there cannot be two opinions, sir, about the need for speedy disposal of the cases under marriage law. But what we have to carefully examine is that by merely passing the laws, is it going to serve the purpose? Is it going to achieve the objects? Sir, why I am saying this? There are similar provisions in the Hindu Marriages Act, sir. For example, Section 21B of the Hindu Marriages Act stipulates time limit for original petition, 6 months time limit, and for appeals 3 months. And similarly, sir, amended Rule 11A in Order 41 of CPC also stipulates time limit. But in reality, we know this is followed more in breach. Sir, in high courts, particularly I can tell about the High Court of Andhra Pradesh, the appeal takes not less than 10 to 12 years before it is finalized. Therefore, sir, what my submission is that merely passing the laws is not sufficient, and we must make sure that the cases are disposed of expeditiously. Sir, in this connection, I have two suggestions to make. Sir, there must be a provision to say that if the application is not disposed of within 60 days, the respondent, the husband, should be made to deposit 50% of the amount claimed. Only then there will be pressure and there will not be any frivolous adjournment, sir. So this is a very important suggestion which I want the Honorable Law Minister to take note of. And my second suggestion is, sir, just like in the Industrial Disputes Act, if any appeal is filed against the orders of the trial court, 50% of the amount awarded must be deposited, sir. Only then the appeal must be allowed. So
माननीय प्रभाकर जी, एक मिनट 5 बज गए हैं। अगर आप लोगों की राय हो तो इसको, इस विधेयक पर विचार जारी रखा जाए। यही राय, ठीक है।
उपसभापति जी, इसके ऊपर मेरे ख्याल में 3 घंटा समय तय किया गया है, इसलिए ऐसे भी इसका वो हम अंत नहीं कर सकते हैं।
नहीं ऐसा है, हाँ ये जो राय दी है आप लोगों ने, लेकिन 5 बजे का एक सप्लीमेंट्री जो एक अनुपूरक जो कार्यावली आई है उसमें माननीय जसवंत सिंह जी को एक स्टेटमेंट देना है, तो वो तो 5 बजे का टाइम दिया हुआ ही है, तो इसलिए इसे अब समाप्त करते हैं, कल ये जारी रखा जाएगा। कंटिन्यू नहीं खत्म, 5 बज गया,
5-10 मिनट
5 बज गया, कल कंटिन्यू रहेगा, कल कंटिन्यू रहेगा, उन्हें फिर उन्हें टाइम मिलेगा, उन्हीं को टाइम मिलेगा। माननीय जसवंत सिंह
అంటే ఇది మెంబర్ అయిపోతుంది కదా మళ్ళీ మధ్యలో ఎందుకు ఆయన జస్ట్ లే అండ్ విల్ హావ్ కాలింగ్ అటెన్షన్ సమ్ మోర్ క్వశ్చన్స్ అండ్ విల్ టాక్ छोटा yes
certainly Mr. Vice Chairman, sir, at the end of it, if you like, I'll say that I'm Mr. Vice Chairman, sir, there was a minor ammunition-related accident in the laboratory located in Ammunition Technical Area, ATA, of the Central Ordnance Depot, COD, Jabalpur, on 6 August 2001 at approximately 2:30 p.m. Unserviceable ammunition, which was being broken down prior to its disposal, ignited, resulting in some of that unserviceable ammunition containing pellets incendiary nature also igniting. The activity of breakdown of unserviceable ammunition does involve degrees of such risk. That is why it is undertaken in a laboratory.